For final disposal, item 3, first appeal 177 of 2023.
My senior will be arguing. Lordship, there was an IA, Lordship. They have filed the IA before appearing of the respondent, Lordship, for adducing additional evidence, Lordship. A certified copy of the sale date, Lordship. So I'm not having the file, Lordship. Lordship, पढ़ दे पहले सीना फाइल देते हैं, but आया नहीं साथ।
Are you there in this case? First appeal with the IA has to be heard along with the first appeal. So it can be.
For adducing additional evidence तो वो ज़रूरी चीज़ है।
ज़रूरी चीज़ है क्या? IA consider होता है at the time of final disposal. That is the law. Or additional evidence in first appeal is considered at the time of final hearing of the case. Basically, final disposal में लगा है.
Lordship, if they may file a reply on the IA.
If they are not filed a reply, it's not your headache.
Yes.
Then, if they are not responded to IA, that is not your problem. That is their problem. So,
Lordship, file is not.
FA 177 अपनी.
Lordship, कोई pass note for one.
नहीं आपको cost लगाएंगे.
One case, Lordship, my senior just.
एक case में तो हम बिना फाइल के खड़े होते हैं. सीनियर फाइल अपने पास देख करते हैं. कॉस्ट का तो केस बनते ही नहीं.
फाइल पढ़े हुए हैं.
आपकी मेमोरी बहुत अच्छी मेरी क्लियर कि बिना फाइल देखे आप ऐसे.
Item 4, first appeal 258 of 2023.
I feel this case may be taken up next week.
नहीं हो
In this
सकता.
case,
नहीं हो सकता है. नहीं nobody else हम पूछ रहे हैं.
in this case, Mr.
नहीं हो
Sandeep
सकता.
Verma has to heal Lordship.
नहीं आप पिछली बार भी यही काम कर.
नहीं इसमें हम टाइम नहीं लिए देख लीजिए
हम
Lordship.
एडजर्नमेंट के लिए कम कॉस्ट लगाएंगे 25,000 से एक पैसा कम नहीं लगाएंगे. नहीं हो सकता. पिछली बार कोई नहीं आप ये बोलते उस दिन डिस्कस कर देना. उस दिन डिस्कस करना चाहिए था हमको. हम नहीं देंगे. फाइल को
काफी
कॉस्ट लगाएंगे एकदम पक्का.
फीवर
कोई एडवांस नोटिस नहीं है.
हाँ एडवांस नोटिस
नहीं
अचानक
है तो फिर
उनको तबीयत खराब हो गई.
अचानक तबीयत खराब हो गई तो भी कॉस्ट होगा. कोई एडवांस नोटिस नहीं है. छुट्टी के बाद पहला दिन है. नहीं होगा. फाइल नहीं आपके पास.
फाइल तो उन्हीं के पास है Lordship.
तो
तो हम कर
आप अपीयरेंस रिकॉर्ड करेंगे नहीं.
नहीं हम तो प्रेयर कर रहे हैं जो बिहार
नहीं हम
मिनिस्टर
बिना कॉस्ट के एडजस्ट नहीं करेंगे.
आज बंद छोड़ दिए
हम कॉस्ट करेंगे ना.
आज बंद
हम छोड़ दे रहे हैं. आज 28 लाख रुपए रिकवरी का केस है. आपको 25,000 रुपए फाइन कर देते हैं.
आज इसमें छोड़ दिए हैं Lordship. तबीयत खराब है लिए देर पर आए.
नहीं पिछली बार नहीं आए थे. उस समय क्या हुआ था उस समय?
पिछली बार उनको जानकारी नहीं है Lordship.
तभी से बीमार चल रहे हैं क्या?
नहीं
बीस
अभी
दो
से
2025
नहीं आज सवेरे से उनको बोला काफी अधिक फीवर हो गया.
नहीं, हम ये सब बात नहीं सुनी. कोई एडवांस नोटिस नहीं है. हम ऐसे चल रहे हैं. ठीक है मैं जॉइन कर दूंगा. कब करना है बता. बिना कॉस्ट के जॉइन नहीं.
नहीं आज के बाद कोई भी डेट रख दिया
आज के बाद कल रख देते हैं ना. रात में फीवर ठीक हो जाएगा.
परसों डे आफ्टर टुमारो
हम रख देते हैं बिना कॉस्ट के नहीं है.
पोस्ट प्रेयर
नहीं करेंगे. FA number 258 of 2023. This case has been fixed for final disposal. When the case is called out, Mr. Kundan Kumar Agastya submits that Mr. Kundan Kumar Agastya seeks adjournment on 20/2/2025 also. Nobody had appeared on behalf of the parties, and the case was fixed for today. The order dated 20/2/25 was uploaded on 24/2/2025. No advance notice has been circulated for adjournment. However, since he is seeking adjournment, and has made a request that the matter be posted the after tomorrow, let this matter be posted the after tomorrow under the same heading, subject to payment of cost of the fees, 10,000 to be deposited prior to the next date of hearing, failing which this appeal will stand dismissed without any hearing.
5
इस ऑर्डर को लेके आगे साइन करेंगे अपलोड कर देंगे
Lordship 5 प्रेयर
बात करिएगा एक सुनना और लगा
नहीं हम नहीं हम तो प्रेयर कर रहे हैं
ऑर्डर आप जाइएगा यही भेजिएगा हम साइन करेंगे पूरा
one pass
Pass over to item 3. First appeal 107 of 2022.
His Lordship, I have one IA is there, Lordship. 11574.
has to be
Yes.
heard along with the
Yes.
Your Ladyship, the copy of the IA we kindly be handed over because it was not served.
Since Lordship, they appeared after my filing.
idea is for additional evidence of one registered document
Document.
जो इन्होंने कभी प्रोड्यूस नहीं किया
Precisely.
That is an admitted fact,
The
Lordship.
basis of that itself, the case was dismissed.
Only that is the basis, Lordship. What my submission is, since Lordship, it has been admitted in
why
WS.
did you produce it
Lordship.
why did you produce it
Only
At the
one.
relevant point of time.
One thing is there, Lordship, that since they have filed a WS, in the WS, Lordship, the title of the Madan Mohan Pandey has not been denied. In entire WS, in their, they have not produced a sheet of paper, neither they have produced any witness.
Then why do you need additional evidence?
Lordship, since that is the only ground, the trial court, Lordship,
Trial court may have any number of
yes, Lordship.
If
Only
there is
Lordship,
an admitted fact, it need not be
only Lordship to cover up my lacuna that was there. Since Lordship, now it is an admitted fact that they have admitted the title of the Madan Mohan Pandey, which has been registered by the housing.
No additional evidence is required.
If whatever Lordship my document is required to
You
be,
will hear it along with the main.
yes.
How much time do you need to respond to this?
Your Ladyship, it may be handed over.
Ah.
I'll further reply within a week.
Yes, sir.
Within a week, I'll further.
If number 177 of the then it comes for the parties are present. Also for document is submitted that one ID number 11574 of 2023 has been filed seeking to adduce additional evidence before this court. The additional evidence ought to be introduced at first appellate stage is the registered document,
Lordship, registered sale deed
registered sale deed number,
dated 13/8/1990. Lordship, number of registered. 8734.
and sale deed number 8734
Dated
dated
13/8/1990.
13/8/1990.
Lordship.
Also for the respondent, prays for time to respond to the interrogatory application. He submits that one week would be sufficient. Hold this case on next Tuesday under the same heading.
On Tuesday, Lordship, one or another case, Lordship is fixed. If it is on Wednesday or any other date, Lordship.
On Wednesday
Lordship.
under the same heading. It is made clear that the interrogatory application will be considered
Along with
along with the final disposal of the first.
since Lordship, the admitted things are not required to be proved. That is also one of my arguments.
Let us say the
Yes.
Orders
The
wittified.
parties are directed to prepare motion for final hearing.
Orders wittified item 5. First appeal 106 of 2022.
Your father?
State.
Nobody appears on behalf of the applicant, counsel for the state.
Respondent 50.
Respondent
55 G. State of Bihar now. Deputy Commissioner.
Respondent number 50 is present. In spite of the heated opportunity that debates have not been made. Time till of April is granted to the applicant to remove the surviving defects or to file an integrated application in connection with one or the other. Claim which the present appeal is time dismissed without reference to the condition. निर्णय claim की वजह से कोई आइए फाइल कर भी छोड़ दें, वो अगर मान लीजिए कोई आईए नहीं फाइल हुआ या बाद में फाइल हुआ है तो कुछ बिना हमसे पूछे बेंच में केस should not come to the bench if the order has to be executed. मान लीजिए कोई आईए एक लिमिटेशन कर रहा है, मान लीजिए कोई और आईए फाइल की इसको इग्नोर करना है, तो उनका काम है कि उसको मेंशन करके हाँ विद इन टाइम उस ऑर्डर को इग्नोर करना। और अगर आईए फाइल हो चुका है इन कनेक्शन विद वन और if this order is complied, suppose it on 17 April.
Item 6. Second April 34 of 2023. Account filing, sir.
Defect has been removed, Your Lordship. Court fees has been paid on 11th itself.
There is an idea for ignoring it.
But that it was for ignoring the defect. But now it has become infructuous because it was already sent to the learned court below for correcting the defect by the last order.
Essay number 34 of 2020. The learned counsel for the appellant has submitted that the defects have already been included. And so far as IE number 1267 of 2025, filed on 15 March 2025 is concerned, it relates to ignoring defect number 1 and establishes that the said integrity application has become infructuous and does not want to test its integrity. Accordingly, IE number 1267 of 2025 is dismissed as proposed. Office is directed to this case and the appropriate hearing on next month.
Okay.
Item 8. First April 71 of 2024.
This appeal filed by the state. Only one defect lordship remains, that is defect number 1. Limitation petition to be filed. Pray for 3 weeks time lordship.
Statement number 71 of 2024. Counsel for the appellant, please vote and is granted. Time till 15th of April to remove the surviving defects pending. If the defects are removed in time, close this case on 17th of April.
For admission, item 21. First April 159 of 2024.
Sanket. Sanket.
Accepting wakalatnama on behalf of the defendants. Taking responsibility after this. FA number 159, Mr. Kumar, accused on behalf of the defendants. ID number 1233 of 2024 has been filed for accepting wakalatnama on behalf of the respondents.
That IA has been disposed of.
और इसमें क्या है? Admit करना है कौन? फिर से FA number 159 का punishment. Counsel for drafting and express global actions on behalf of the respondents. Although they have enjoyed appearance soon by filing wakalatnama. Suit ID number 13300 which has been allowed by order to 7 months. For a response from the concerned court. Since the respondents have already appeared, no notice need to be issued. There is already communicated to the facts. Close this case on.
For hearing item 23, second appeal 2 of 2016.
My tender apologies for not having late.
Obviously, thank you very much.
No.
I'm गर्मी का मौसम आ गया है। चाय, पानी, ग्लास सब लेना चाहिए। देखो, दौड़ के आते हैं यहाँ पर। Madam, please have a seat. We talk about this tomorrow.
Yes. Yes, ma'am. The matter was admitted on the following substantial question of law. May I?
Yes, this is first opinion.
Yes, yes, second
Yes,
opinion.
yes.
Yes.
Yes, please.
When-
Let us take this offline.
Yes, ladies.
Already. Already. 3178.
Yes, ladyship. 31/7/18, the matter was admitted.
Read this order.
Order copy I do not have, I just have the substantial question of law with me.
Okay, read this.
Whether in view of the fact that major portion of the suit property was sold back during the period 1986 to 2000 and the plaintiff never objected to the said sale or handing over the possession to the purchasers, the suit is barred by principles of waiver, acquiescence and estoppel. Second, whether in view of the fact that all the other co-sharers of the property have affirmed the previous partition amongst the co-sharers and also distribution of the share of the consideration among all the co-sharers, including the plaintiff, the present suit for partition is maintainable. Whether in absence of any separate source of income, admission on the of the plaintiff of purchasing a new house and also having an old house over the part of the suit property proves previous partition amongst the co-sharers and also sharing of the consideration amount received against the sale of part of the suit property which has been specifically affirmed by all the other co-sharers in their evidence. Ladyship, the suit was filed for 1/7 share of the suit property. I'm just elaborating over the genealogy.
Let us see that genealogy might not be disputed.
No, it is not at all under dispute. She is one of the sisters and one of the daughters of plaintiff number one, defendant number one, and other brothers who are the defendant, rest of the defendants. And she is one of the sisters of them and daughter of defendant number one.
Give the genealogy, just the background.
Yes.
Who is a common ancestor?
Hemchand Gorai. He is the common ancestor of plaintiff and defendants, and he was the owner of the suit, and he died in the year 1976.
Owner of property, sent on
Yes.
died in
1976.
1976.
Leaving behind, defendant number one is the widow, Sarla Baragorai. Defendant number two is the eldest son, Sagar Chand. Defendant number three is Dhiren Chandra Gorai. And there comes the name of the plaintiff in the order of his children, Srimati Chavi Gorai. She is the plaintiff. And then daughter Srimati Bhanu, and thereafter one daughter Srimati Renuka. Other daughters are also the defendants in this
Defendant
one.
number 4 and 5.
Yes, they are defendant number 4 and 5. And defendant number 6 is Srimati Geeta Gorai.
Six are all sisters.
All sisters.
4, 5, 6 are sisters.
Yes. And they all are married sisters. Even the plaintiff is the married sister and married daughter of defendant number 1. Certified copies of 4 Khatiyan has been exhibited, ladyship. That details are required to be seen before we go into the Khatiyan number, Khatiyan Khata number 1 to 17. 929 जी 929 930 and 1108. These are exhibit number 1 to 1 by C. These are certified copy of 4 khati. Yes. Leadership, as far as khata number 1 to 17 is concerned, this is recorded in the name of Anabad Bihar Sarkar. And out of which, in 1 to 17, plot numbers 2343, 2345, 2337, 2338, 31, and 2191 has been shown as illegal possession of Hemchandra Gorai in the remark column. Hemchandra Gorai is the common ancestor. In the same khata mein, some plot 1230 and 1232 has been shown to be the land of Disco. Yes, some plots in possession of Disco, that is plot number 1230 and 1232.
Land of Disco and in possession of Disco.
Yes. Next is, this was one khata 1 to 17. Second khata number is 929 and 930. This land has exclusively recorded in the name of Sarla Bara Gorai, that is defendant number 1. That is the widow of the deceased and mother of the plaintiff. Now, leadership khata number 1108, the fourth one. All the lands recorded in the name of Hemchandra Gorai, the common ancestor. All lands have already been sold out. Which is a part of Vijaya heritage. And different purchasers are in the possession of the said property.
Purchases are in.
Yes.
Who are the vendors?
Leadership.
Who are the vendors of this property?
The brothers and the mother. And this was sold long.
Brothers and mother.
Yes. Sold long back in the year
Of
86 of the plaintiff. Yes.
Vendors. What are the dates of sale?
Leadership I have not written here if in case.
Alright, how many sales?
It has been sold by various sale dates from 1989 to 2000. 89 to 2000.
The mother is still alive.
Mother is still alive. She did not come to depose, and that went against me, that she did not come for reading the evidence.
What was the schedule of the
Yes. Schedule B is the schedule at at page number
1 to 1.
yes, 1 to 17.
1
These
to
all the
17 is
khatiyans,
only property which was involved for the purposes of
other properties are also there in addition. 1 to 17,
or 939.
yes, 929, 930, 1108. The explanation that I have just above given.
Yes.
These are the 4 khatiyans and these are the 4 properties.
Let us see what happened because of tried to dismiss the suit.
No, it was in my favor. Yes, it was dismissed. The suit was dismissed and the appellate order went against me.
Let's have a look at the findings, the issue stream.
Yes.
What was the case of the defendants? Who are the defendants who participated in the suit?
Yes.
There were 2 set of written statements that were filed.
Ladyship.
How many defendants were taken? 6.
6.
A joint written statement by defendant number 1, 2 and 3.
Yes, ladyship.
And there is another written statement
By the
defendant
daughters.
number 4, 5.
Yes.
Are they in consonance with each other?
Yes, yes, they are in consonance with each other and they are supporting the case of the defendant.
Let's have a look at it. What was the case of the defendants?
Ladyship, para 3 onwards, that is the case of the defendant. As per joint WS filed by defendant number 1, 2 and 3, the suit is not maintainable in its present form, and for the relief claim, suit is barred for misjoinder of the parties and it is also barred by limitation. Defendants have admitted that Hemchand Gorai was the father of the plaintiff and defendant number 2 to 6, and defendant number 1 is the wife of late Hemchand Gorai, who died in or about 1976. Defendants have denied about any share of the plaintiff with respect to the Schedule B property because the entire property does not belong to late Hemchand Gorai. Fact of joint possession of the suit properties have also been denied by these defendants. Plaintiff has filed a simple partition suit, but properties in question have been recorded as Anabad Bihar Sarkar and Tisco is the lessee from 1/1/1956 for 40 years, and name of Hemchand Gorai has been shown as Anabad Dakhalkar. And unless and until title of Hemchand Gorai is declared from a competent court of law, Honorable Court cannot go for its partition. It has further been stated that the land of Khata number 1217, plot number 70, 72, 109, 110, 2043 and 2044 belongs to Sagar Gorai. Some lands of Sagar Gorai self-acquired. These are the lands of Sagar Gorai which are self-acquired, who is defendant number 2. And it is also self-acquired properties of Sagar Gorai, so there is no question of jointness of title possession with respect to the aforementioned properties. This, it has further been stated that land of Khata number 930 having plot number 2089 and Khata number 929, plot number 26 belong to Sarla Bara Gorai, and it is her self-acquired property from her own fund and Stridhan. So it cannot be partitioned. It has been further stated by these defendants that after the death of Hemchand Gorai in the year 1976, entire responsibility came on the shoulders of Sagar Gorai, and at the relevant time, the plaintiff, namely Chavi Gorai, was of the age 10 years, and defendant number 3 was aged about 15 years, and defendant number 6 at the age of 13 years. Sagar Gorai maintained all the family members and he got his brother and sister married beyond his capacity. Not only that, he also treated his father Hemchand Gorai, making huge expenditure as his father was suffering from blood cancer. The land recorded under Khata number 930, plot number 2089, Khata number 929, plot number 26 in the name of Hemchand Gorai has already been sold with the consent of all the family members in between 1985 to 2000, and consideration amount has been distributed Among all the brothers and sisters of Chabi Gorai, plaintiff has received rupees 18 lakhs, including the lands and the house which has been constructed by Sagar Gorai from the said fund. Except that Hemchand Gorai has got no land and house, hence the plaintiff has no right to claim his brother's and mother's self-acquired properties. There was no occasion for the plaintiff to ask for partition from defendant number 1, 2 and 3, and it is also false to say that she has been driven out from the house without giving any due share. Plaintiff, being the youngest member of the family, was always demanding money from the defendant number 1, 2 and 3, and due to endless demand, she lost the faith of the family members, and out of grudge, the plaintiff has filed this suit for harassing the family members unnecessarily. The partition of the land which belongs to Hemchand Gorai has already been done, and all the members have taken their respective shares by getting land and consideration amount in between 1986 to 2000. Land of plot number 106 and rupees 2 lakh cash for consideration of the house has been given to plaintiff, and apart from construction of house has been given to the plaintiff, and apart from that she has taken 8.5 lakhs for purchasing another house property, and in total she has taken rupees 18 lakhs from the defendant number 1, 2 and 3 for her share, and apart from that she has also taken rupees 2,50,000 for paying chit fund dues. There is no cause of action in the suit because the plaintiff never asked for partition, neither she served the legal notice for the same. It is well within the knowledge of the plaintiff that land and property which belongs to Hemchand Gorai has already been sold out with the consent of all the family members, and she has taken the consideration amount as per her share, but by suppressing the matter before this court, she has filed this case stating that the suit property is a joint family property. No proper valuation of the suit property has been made, and it is not a simple suit for partition because the title of the parties are involved with respect to the suit property. So the present suit property for partition is not maintainable unless and until ad valorem court fee is paid. Property in question is not a joint family property, rather it is a self-acquired property of defendant number 1, 2 and 3, and they are the absolute owner of the same. So the plaintiff has got no share in the suit property. So the present suit for partition is liable to be dismissed with cost. WS filed by defendant number 4, 5 and 6 is same and similar to WS filed by defendant number 1, 2 and 3, and it has been stated that land which belonged to Hemchand Gorai has already been sold, and consideration amount has been divided among all the co-sharers, and they have also got some portion of the land in their respective shares, and house has been constructed over the same by the fund of Sagar Gorai, which is in possession of the plaintiff. The land acquired by Sagar Gorai and their mother Sarlabara Gorai and their mother Sarlabara Gorai are their self-acquired property, and plaintiff has got no share in these properties. So the suit of plaintiff is fit to be dismissed. As per additional WS filed on 28/8/2008 by defendant number 1, 2 and 3, land of Khata number 1217, plot number 2045 is the land of Sagar Gorai, and it is the self-acquired property, and it has not been mentioned by the plaintiff that when she came to know that the aforesaid land has been wrongly recorded in the name of Sagar Gorai, and why so, under the aforesaid facts, the circumstances, the suit is barred by limitation.
We have seen the written statement as recorded in the records. There is no such case as previous partition.
Leadership, in the WS as well as in the deposition.
One thing to say that it was shared, the consideration amount was shared, but there is no such plea as previous partition, that there was a previous partition. There is no such plea.
No, the plea is by the defendants. They have taken a plea that because Hemchand Gorai died at the early age, Sagar Gorai, he maintained the family, being the Karta of the family, he maintained the family, and during the course he got all his sisters married and everything.
That's like
And
he
he
spent a lot of money on it.
he
He spent a lot of money for the treatment of water. He
Yes.
spent a lot of money to bringing up the children. They were all minor at that
Yes.
time. Some of the property was standing in the exclusive name of the wife of him.
Yes.
But there is no such case of previous partition.
No, everybody has said that it was not partition. It was as per the depositions also. They say that the entire land in the name of the a common ancestor has been sold and the amount has been divided.
That's right. But
Yes.
does it amount to previous partition? That is not previous, that is not the concept of previous partition. The very fact that the amount they claimed was that the consideration amount was divided amongst all, it itself shows that there was a joint.
And further, it has
When it
also
comes to previous partition, it is partition by means and bounds or equitable partition amongst all. Merely because some property is sold and the consideration amount is divided amongst the shareholders, that does not mean that it's
not only the consideration, ladyship, even the land. Some of the land has been divided, and that is admitted by the plaintiff.
which land has been divided.
She has admitted that the old house of the father, she still has the possession,
Maybe
and
she
over
has-
the land of his father.
You see, possession of a joint family property may be with any one member, exclusive possession, but that does not amount to partition. Like, it's very common in village home, you may have lots of property. Maybe one brother is residing there and you don't go there for 50 years also. Right? He neither can claim adverse possession because there is no partition. And you still have a right of partition.
So the
So
common
I am not able to get how a previous partition issue has come because an issue has been framed about previous partition. There is no plea of previous partition.
there is a plea that in the maintenance of the common ancestor's property has already been sold with the consent. The common ancestor's property, the portions, the land has been divided among the siblings of defendant number 2, ladies.
The land has not been divided. The consideration amount out of the sale has been provided.
That has been given,
That has
and she has been given the old house of the father, and she has constructed a house also with the
that's
consent.
not there. in
Yes,
the
yes, that is.
Where is it there? Where is it in the legal statement? That she has been separated from the joint family and then she has been given her share in the shape of house. And that is her exclusive property. It is not there in the legal statement.
May I read para 1, ladyship? Because in brief, as per plate, the parties are Hindu and they are being governed by Mitakshara School of Hindu Law and Hindu Succession Act in the matter of inheritance and succession. Genealogy has been depicted in Schedule A, showing the relationship of parties. The common ancestor of the parties are Himchand Gorai, who died in or about the year 1976, leaving behind the defendant number 1 as his widow, defendant number 2 and 3 as his son, and defendant number 4, 5, 6 and the present plaintiff as his daughter. So, according to Hindu Succession Act, each of the defendants and plaintiff will get 1/7 share in Schedule B property, which belongs to Himchand Gorai, situated within JNAC, Ward number 2, Jamshedpur. Some of the properties have been recorded in the name of Anabad Bihar Sarkar, and in the remark column the name of Tata Steel as lessee since 1956 for 40 years, and have shown through illegal possession of Hemchand Gorai has also been mentioned in the remark column number 7 in some of the khatiyan which have been recorded in the name of Anabad Bihar Sarkar, and some of the lands have been recorded wrongly in the possession of Sagar Gorai, defendant number 1, and also some of the land have been wrongly recorded in the name of Sadla Bara Gorai in Khata number 929 and 930. So far as land of Khata number 561 and 562 is concerned, which has been recorded in the name of father of the plaintiff, the said land falls within the jurisdiction of Ghatshila court, so the plaintiff reserves her right of filing a separate suit at Ghatshila. The land which were in possession of Hemchand Gorai are now being looked after by the sister of the plaintiff, namely Meena Gorai, on behalf of the plaintiff, and she is giving yearly share of the usufructs of the land of the plaintiff. There has been, this is important, ladies, there has been no partition in meets and bounds among Hemchand Gorai and his other co-sharers. In spite of the aforesaid wrong entry, the parties are in joint possession of the suit properties, and the properties in question are all immovable properties, and the parties are rayats with respect to those lands. The properties which have been mentioned as house should also be guided by the incidents of the Rayati land. Parties are the member of Hindu joint family, and the daughters of Hemchand Gorai, though have been married away, are also entitled to their share equally with respect with their brothers as per Hindu Succession Act. On 14 January 2007, the plaintiff had gone to the house of the defendant number 1, 2 and 3 and asked them for dividing the ancestral land amicably, but they rebuked and plaintiff and driven her away from the house of other parties. So, under such circumstances, it has become necessary to file the present suit for partition of the properties at Hemchand Gorai in meets and bounds, which has been fully described in Schedule B below, and hence this suit. The cause of action of this suit arose against the defendant on and from 14 January 2007 at Kadma within the jurisdiction of this court for the purpose of court fees such and such. So the plaintiff has paid and fixed, and she has preliminary decree. So the plaintiff is entitled to a preliminary decree of 1/7 share in the Schedule B property along with other consequential reliefs. Now, ladyship, it has come. She herself admits that the old land of the father, from that whatever amount is getting, the sister is giving this to this lady.
Part. Only part. Not everything.
Here on behalf, and giving yearly share of the
Yearly.
share.
Only share.
Yes, share is being given.
Something is being generated for the involved property, so she is getting a share.
Yes, and this has been admitted by the defendant, ladyship. By the plaintiff, TW1, that she bought the new house, no source of income has been disclosed, has the knowledge of the sale suit since 1989, knowledge, and she has got her.
I don't see a case of previous partition. There's no case of previous partition.
Now, ladyship, even if we go by that there is no previous partition. Now, this is an admitted fact. That is why the suit has, that issue has been framed. Whether it is maintainable or it is barred by the stopple and acquiescence and delay and laches, ladyship. In the
property was sold only in connection with part, not the
entire property in the name of the common ancestor has already been sold. Now, rest of the properties are either in the name of the mother, defendant number 1, or in the name of Sagar Gorai, defendant number 2. Now, that is self-acquired property.
See, once you say that there is a nucleus in the family, then the property was self-acquired. The owners goes straight away to the dependents. What was the source of income for Sagar Gorai to say that it was a self-acquired property? What was the source of income so far as the mother is concerned that it was self-acquired property? And you say that she never deposed before the court.
No, she never deposed.
So you even disclose that it was her self-acquired property.
In the WS, it has been disclosed that
WS
it
is nothing. WS is not.
Sridhan.
WS will not become a part of evidence. And so far as a portion of the property which they say in the name of Anawad Bihar Sarkar and illegal possession of what this particular suit is not for deciding the title between the parties. Whatever it is, whatever be the right. Suppose a person is residing in a house and there is a dispute that the land does not belong to the person. Still, if there is a partition suit, the court will not go into the title of the property. The court will only go to whatever be the nature of the title, whatever be the dispute with third parties, whatever be the dispute with this court, whatever be the dispute with state of Bihar or state of Jharkhand. That is not the subject matter of this case. Still, the property in possession of the parties is still right.
ladyship, the Sridhan, she has purchased the lady.
So where? What is the evidence? She herself does not come. To say that she had money or she had freedom,
No, she did not come and
They-
depose, but the other defendants, they have
they
deposed.
cannot depose on
Then
behalf.
their mother, they have
They
purchased.
cannot depose.
And the other land which is recorded in the name of Sagar Gorai, defendant number 2.
So once he says that it was his property, what was his source of income? Has he given his source of income?
He has stated that thereafter he had a business, he sold the cattle and all to maintain the family. And the suit land which
He
was
sold cattle to maintain the family.
to maintain the
But
family.
there is no evidence that he had money to buy the land. Selling cattle is another thing. He has got no business to realize it. He might have spent in the wedding of a daughter, crores of rupees is spent, right? That will not constitute a share in the wedding. It's your own relation. You keep on spending money to possess a property. But when it comes to partition, she has a share.
Ladyship, there is a judgment.
Isn't it? Merely because some money has been spent, that some money might have been spent for treatment, some money might have been spent for anything, like for marriage or for education. That will not take away the nature of that will not be counted for the purposes of earning the share of it.
Ladyship, the judgment of Honorable Supreme Court is there. Para 10, 12 and 21. Person who alleges Hindu undivided family has to prove it. One who is saying that it is undivided, that person has to prove it.
That's right, but it's an admission that it is an undivided family. Because once you say that the sale proceeds of land was distributed amongst all, you admit. You admit straight away, you admit. That amounts to admission.
Ladyship, all the co-sharers with the consent of the sharers, they sold their suit property, which was exclusively in the name of the common ancestor of all of them.
It means that there was joint in the family. Otherwise, why would a person when selling a property will give a portion of it to any one of the sisters? Why should? And whenever there is a partition, suppose there is a property of 1 crore. Out of that property, 50 lakhs, 50% has been sold. Then whenever there is a partition, there will be a notional partition with respect to the entire property. And then amongst that notional partition, it will be seen as to how much one has received, and there will be an equitable partition on that. There is no legal bar in selling undivided portion of the property. Undivided portion of Hindu joint family can always be sold. But when it comes to partition, the person who has taken the money and the person who has sold that portion, he gets that his share gets deducted accordingly. Simple.
Yes, the entire joint property has been sold out.
No. You see, Sagar says that it was his self-owned. Is there any evidence on that?
It is recorded in his name and it is a self-owned property and it is recorded since long. She never objected to that. In the year 2007, that is why the first question has been framed with respect to barred by laches, delay and estoppel and acquiescence.
They are not challenging the same. There is no challenge to the same.
No, these facts have been suppressed. It has been shown. She has admitted later on that she had the knowledge that from 89 to 2000, 85 to 2000, the entire property has been sold out.
Not that. Only the property, portion of the property which was standing in the name of
Common ancestor.
common ancestor. So far as mother is concerned, she never deposed that it is a 3
No. But rest, even the other daughters and all they have deposed. that it was the share of the mother and it was self-acquired property of the mother from her Srihan. And nothing,
So they have a sale deed.
sale deed, no, sale
If
deed
it
has
is
not,
self-acquired property, then there has to be a document of title
no, that has not been exhibited.
that it is no such document has been
Exhibition ये जो exhibited documents are the 4 khatiyans. These are the
No
certified.
sale deed has been exhibited.
No sale deed has been.
Even the property which has been sold,
No sale
even
deed.
their sale deeds have not been exhibited.
It is an admitted fact that it has
Admission
been
is
sold.
valuable because the sale deed also has a number of recitals as to how and why a person is selling. So those sale deeds have not been exhibited. There is the document, the property standing in name of Sagar. He must have purchased it because you say that he purchased it from his own source of income. Is there any sale deed in this statement which has
No,
been
that has
exhibited?
not been exhibited.
So none of the sale deeds. It is just a mere statement that mother bought the property from her own income. Sagar bought the property from his own income. But there is no purchase. There is no evidence of purchase.
Sale deed has not been exhibited.
Sale deeds have not been exhibited. Okay, let us see the finding.
I am reading out the issues first, Letitia. Is the suit as framed maintainable and has the plaintiff valid cause of action for it? Was there any previous partition with respect to the suit property and the payment of consideration money to the plaintiff by the defendants have been made after the sale of the property recorded in the name of father of the plaintiff or not? Are the land recorded in the name of individual members their self-acquired property? Is the plaintiff entitled to the decree for 1/7 share of the suit property in the suit property? To what other relief or reliefs plaintiff is entitled to? Issue number 2, 3 and 4.
I mean, these are the main issues.
These are the main
Yeah,
issues.
that's
Yes.
right.
These are the main issues in the present suit and interconnected and interrelated to each other. So these issues are taken together firstly for the sake of convenience. From the side of plaintiff herself has come to depose before the court as PW1. She stated in her examination in chief supporting the plaint that Hemchand Gorai was the father of the plaintiff and defendant number 2 to 6 and defendant number 1 is the widow. It has been further stated that all the land mentioned in Schedule B is the land of Hemchand Gorai, but some of the suit lands have been recorded wrongly in the possession of Sagar Gorai and Sarla Bara Gorai in the remark column, though they are in joint possession of the suit property, and when the plaintiff asked for partition of ancestral land amicably, it has been refused by the defendant number 1 to 3. So she has filed the present suit for partition of her 1/7 share in the suit property. Land of Khata number 1217, plot number such and such, belong to Sagar Gorai, who is defendant number 2 in the present suit, but it was never acquired by Sagar Gorai and the same has been acquired out of joint family income. It is also false to suggest that land of Khata number 930, plot number 2089, Khata number 929, plot number 76 belongs to Sarla Bara Gorai as it is her self-acquired property. She has never purchased the same out of her own income. Rather, it is the property acquired by joint family fund. All the lands have been sold after the death of Hemchand Gorai and it is not true that plaintiff always used to demand money from the defendants. It is also false to suggest that there has been partition of land belonging to Hemchand Gorai. It is also not true that plot number 106 and rupees 2 lakh cash as construction cost of house has been given to the plaintiff apart from rupees 8.50 lakh for purchase of another house property, and in total rupees 15 lakhs she has taken from defendant number 1 to 3 in lieu of her share, and apart from that she has taken rupees 2.50 lakhs for paying chit fund dues. It is also false to say that suit property mentioned in the schedule is not a joint family property and defendant number 2 and 3 are the absolute owner of the suit property. Rather, suit property is the joint property and she is entitled to 1/7 share in it. During her cross-examination, she said in para 23 that she is presently living in the new house purchased by her and she has left the old house which is situated on the land of her father, but it is still in her possession. The area of said land is 1.5 kattha to 2 kattha. In para 24, she said that near her old house, Vijaya Heritage Flat has been constructed in the year 1989, which has been constructed on the land of her father, and also land of other persons have been acquired by Vijaya Heritage. She said that the land of Khata number 1217 is purchased land of her father. In para 25 of her cross-examination, she was unable to say whether plot number 70 and 72 of Khata number 1217 is recorded in the name of his brother as Abad Dakhalkar in remark column, and land of Khata number 1217 has been recorded in the name of Bihar Sarkar or not. In para 27, she has further stated that the land of Khata number 1109 belonged to her father, but whether it is still existing or not, she is unable to say. She was further unable to say that whether the land of Khata number 930, which is recorded in the name of mother, has been sold or not, but she further said that most of the lands have been sold out. In para 29, she said that in the year 1976, she was 11 to 12 years old and her mother has performed her marriage and her mother is still alive. She has denied about the help of 2,50,000 provided by his brother for the payment of chit fund. She has also denied about the payment of rupees 8 lakhs by the defendants for the purchase of the new house by her. She has also denied about the fact that after sale of land, his brother has given her 18 lakh rupees. She has denied this fact that presently no land remains in the name of her father and whatever is the land is available, it is in the name of mother and brother. She has denied this fact that she has filed a false case and deposed wrongly in it. PW2 Kamal Madhav has said that said land previously belonged to Hemchand Gurai, which is situated in Ulyan, having 5 to 6 bighas, which consist of 40 to 50 plots. No partition has ever taken place amongst heirs of Hemchand Gurai, and Chabi Gurai has got 1/7 share in the suit property. Chabi Gurai has also purchased a piece of land near the suit land and she has constructed house over the same out of her own income. During his cross-examination, he said that his house is at a distance of 1.5 kilometers from the house of Sagar Gurai. He further said that he has written in the statement that 40 to 50 plots of the land is in possession of Sagar Gurai. Khatiyan of aforesaid lands have been shown by Chabi Gurai to him 2-3 days before. He further said that since Chabi has told him that no partition has ever taken place, he has written these facts in his examination in chief on the basis of her statement. He also said that Chabi is entitled to 1/7 share in the suit property. In paragraph 16, he said that he has got no knowledge about the purchase of the land by Chabi Gurai. In para 17, he said that on the request of Chabi, he is deposing in this case, and it is not true that on the request of Chabi Gurai, he has deposed wrongly in this case. DW1 Sagar Gurai. Sagar Gurai has supported the contents of his WS as a whole and said that the entire suit property is not the property of Hemchand Gurai. Some of the suit land have been acquired by him and his mother, and the land belonged to his father Hemchand Gurai has already been sold, and Chabi has got the proportionate share in consideration amount, that is 18 lakhs, including land and house allotted to her, which is situated on the plot number 106, and rupees 2 lakhs cash has given to her for consideration of house on the said land. She also received rupees 2.50 lakhs for paying chit fund dues. Rupees 8 lakhs has been given to her by the defendants for purchasing the new house in which presently she is living. It is also true that entire suit property is a joint family property and the plaintiff is entitled to get 1/7 share in it. It is well within the knowledge of the plaintiff that property which belonged to Hemchand Gorai has already been sold out, but after suppressing the said fact, she has filed the present suit on the false ground. During his cross-examination, he said that the father was suffering from blood cancer and he was admitted in the hospital in the year 1975, and to clear his debt, all the cattle were sold after the death of his father. Since 1985, he started selling the land for money, and after that, for construction of the flats, land was sold out and he received the money. In sale deed, name of sisters have not been shown as owner, and it has not been mentioned in the sale deed that sisters are also agreed to sell the lands in question. He further said that he has got no any documentary proof that rupees 18 lakh has been given to the plaintiff after sale of the land in cash and kind. He said that rupees 2.50 lakh has been given to the plaintiff for chit fund dues. He further said that her mother is in possession of the house and she is receiving the rent from the renters, which is 4,000 per month. He accepted that the suit land for which the present case has been filed is recorded in his father's name in the Khatiyan of 1996. Plaintiff has filed the present suit because the suit land has not been partitioned. On recall, DW1 has further stated that land of Khata number 1108, plot number 76.
Now we have seen the living family. Just read it quite fast. You can come to the you can see the observation from the side
From the side of the
it was argued. What was the argument?
From the side of the plaintiff, it was argued that the land described in Schedule B of the plaint is the joint property of the plaintiff and defendant, and originally late Hemchand Gorai was the owner of the entire land, and some of the lands recorded in the individual name of the family member is also a joint property because they have got no separate income to acquire those lands, and it has been admitted by the defendants that no partition has ever taken place by meets and bound. So entire Schedule B land is a joint property, and plaintiff, being one of the member of the joint family, has got her 1/7 share in the suit property. So she is entitled to get 1/7 share in the suit property. Ruling referred by the plaintiff in support of her contentions 204 JLGR page 208, which relates to the transfer of joint property by the co-sharer. From the side of the defendant, it was argued that the land shown in illegal possession of Sagar Chand Gorai was, with respect to Khata number 1217, his self-acquired property because he came in possession of those land by his personal efforts, and it has not been purchased by anyone. So plaintiff's claim with respect to 1/7 share in those lands is not tenable at all. In the same way, land shown in illegal possession of Sarla Bara Gorai with respect to Khata number 1217 is also not divisible because she came to the possession of these lands by her personal effort. So the plaintiff's claim with respect to these lands are also not tenable. It was further argued by the defendants that the land recorded in the name of Sarla Bara Gorai with respect to Khata number 929 and 930 is a self-acquired property, and she has purchased it from her Stridhan. So it cannot be treated as joint family property, and plaintiff has got no share in it. It was further argued that so far as land recorded in the name of Hemchand Gorai with respect to Khata number 1108 is concerned, it has already been sold with consent of all the members of joint family and consideration.
With respect to 1217, Sagar Chand Gorai said that it was his own property, but he has not purchased it from anyone.
Self-acquired property.
Self-acquired means self-acquired is only to purchase,
Yes.
but he has not purchased it from
He has not exhibited any sale deed.
It was only the record of rights, Khatiyan.
Khatiyan
he was
his
shown to
name
be
is.
in illegal possession. With respect to 1217 also, he says that Sarla Bala Gorai,
Khata
the
number
wife-
929 and 930 is the self-acquired property by
the self-acquired is purchased from
purchased from Sri.
Purchased from Sridhar, but this deed was not produced.
No, deed was not produced.
But with respect to 1217 again,
Hmm.
it has been said that it has been recorded in her name and therefore it was from her own personal effort. But it is not a case of purchase 1 to 1.
Yes.
It's not a case of purchase.
No.
It is being
Illegal
shown as illegal possession.
Yes, 1 to 1.
929 and 930, she claims that she has purchased it through her street.
Yes.
No deed produced.
No deed.
Proceed. It was further argued.
It was further argued that so far as land recorded in the name of Hemchand Gorai with respect to Khata number 1108 is concerned, it has already been sold out by the consent of all the members of the joint family, and consideration amount has been divided among, and presently these lands are in possession of the purchasers. Not only that, the plaintiff also got 2 kattas of land out of land of joint family, and construction cost amounting to rupees 2 lakh has also been provided to her, and she is still in possession of the said house. Rupees 4,50,000 has also been paid to her at the time of purchase of the double-storied house by her. Not only that, for clearance of her chit fund dues, rupees 2,50,000 has been given to her. In this way, she has totally received rupees 18 lakhs at relevant time. So she has got no share as claimed by her, and the present suit has filed is not tenable and liable to be dismissed. So here the land has also been given to her as her share, and she admits that she has the possession of the land and she is resigning. Thereafter, Khatiyan number 1217, 929, 930 and 1018 has been filed from the side of plaintiff as documentary evidence. From perusal of Khatiyan of Khata number 1217, it transpires that land has been recorded in the name of Anabad Bihar Sarkar, and out of which, with respect to land plot number 2343, 2345, 2337, 2338, 31 and 2191, illegal possession of Hemchand Gorai has been shown in the remark column, but this with respect to other plots of the land, the illegal possession of Sagar Chand Gorai and Sarla Bara Gorai have been shown, and some of the plots have been shown in the possession of Tisco itself as lessee, that is plot number 1230 and 1232. So admittedly the land of Khata number 1217 belongs to Anabad Bihar Sarkar, so it cannot be the subject matter of the partition unless and until title of the land recorded in Abaid Dakhalkar of Hemchand Gorai is declared in his favor by the competent court. So far as land of Khata number 929 and 930 is concerned, it was exclusively recorded in the name of Srimati Sarla Bara Gorai, wife of Hemchand Gorai, who is defendant number 1 in the present suit. Plaintiff has asserted that her mother is housewife and got no separate income, so the land recorded in her name has also been acquired from the joint family fund. So plaintiff is also entitled to get share of the said property because her mother Sarla Bara is also the member of the joint family as admitted by the defendant. From perusal of Khatiyan of Khata number 1108, it transpires that all the land have been recorded in the name of Hemchand Gorai, but defendant has taken a plea that the lands recorded in Khata number 1108 has already been sold for to different persons, including Vijaya Homes, and at present flats have been constructed over the said land and different purchasers are in possession of it. From perusal of admission of plaintiff, who is PW1, it transpires that she has got an old house near Vijaya Heritage Flats, which is on the land of her father, as admitted by her in paragraph 23 of her cross-examination. She has also said that old house is situated on 1.5 to 2 kattas of land, which is still in her possession. She has also admitted that she has purchased a new house, and she is living in the said house presently. It has also been admitted by her that in the year 1989, Vijaya Homes was constructed and it is on the land of his father and other persons which was purchased by Vijaya Homes. In para 25, she said that land of Khata number 1217 is the purchased land of her father, but no any deed has been filed by her. From perusal of Khatiyan, it transpires that illegal possession of Hemchand Gorai has been shown with respect to some plots of the land mentioned above, so it cannot be presumed that Hemchand Gorai has purchased some plots and lands in Khata number 1217 as claimed by the plaintiff. So her statement becomes falsified because documentary evidence, which is Khatiyan of Khata number 1, 2, and 7, suggests otherwise. She said that she has got no knowledge how on some plots of land, Khata number 1217, illegal possession of Sagar Chandra Gorai has been shown. In para 27, she said that she got no knowledge that whether any land in Khata number 1108 is still remaining or not. She was also unable to say about the land of Khata number 930, which has exclusively recorded in the name of defendant number 1, whether the land of Khata number 930 has been sold or not. She has got no knowledge. She further said that most of the lands have been sold. In para 29, she said that her marriage was performed by her mother and the marriage cost was paid by her mother. In para 30, 31, she said that she has got no knowledge that the brother has given her 2,50,000 for clearance of chit fund dues and rupees 8 lakhs at the time of purchase of the new house. From her admission in para 24, it appears that in the year 1989, she has got knowledge that the land of her fathers has already been sold. She said in para 30, 31 of her cross-examination that she has got no knowledge whether she has received rupees 10,50,000 from his brother, that at two occasions even she has also denied the fact of receiving of rupees 10,50,000 from her brother. At two occasions she has admitted that she has got an old house on her parental land and that house still is in her possession. From the side of defendants, it has been said by their witness that the property recorded in a mother's name is her self-acquired property purchased from Sridhar. Nothing has been brought on record from the side of the plaintiff to deny this fact strongly. Defendants have also stated that the plaintiff has got her due share in her father's property time to time and she has also got the house of his parental land. So from the trend of the evidence available on record, it transpires that plaintiff has received her due share in her father's property and she had knowledge in the year 1989 that the land recorded in the name of father has already been sold and flats of Vijaya homes have been constructed on the same. She has also admitted that she has got an old house situated on her parental property. So from these evidence, the court comes to the conclusion that partition has already taken place and the plaintiff has received her due share in the sale proceed of the suit property recorded in father's name. So as a result, issue number 2 goes against the plaintiff and the finding that the plaintiff has received her due share in her parental property. Ruling filed by the plaintiff is not relevant in the present suit. So far as the land recorded in the name of her mother with respect to Khata number 929, 930 is concerned, the evidence has been brought by the defendants that these lands have been purchased by her mother from Sridhar and no contrary evidence is available on the record from the side of the plaintiff of this issue. So far as land shown in illegal possession of the defendant number 1 and 2 is concerned, ownership with respect to the land of Khata number 1217 rests with Anabad Bihar and only illegal possession of Sarla Bara Gorai and Sagar Chandra Gorai have been shown with respect to some plots of the land Khata number 1217. So it cannot be treated as joint family property and the plaintiff is not entitled to get share in the self-acquired property of her mother and in the property which has been illegally been possessed by defendant number 1 and 2. As such, result of issue number 3 also goes against the plaintiff. So in view of the discussions made above, the court comes to the conclusion that the plaintiff has got no share in the Schedule B property and her claim is denied. Thus, in result, answer of issue number 4 has also goes against the plaintiff and the plaintiff is not entitled to get any share in the suit property as claimed. Issue number 1, since the main issue have been decided against the plaintiff, so the suit as framed is not maintainable in the present form and plaintiff has got no valid cause of action for it. Accordingly, answer of issue number 1 goes against the plaintiff. Issue number 5, since all the main reliefs have been negated, so the plaintiff is not entitled to get any consequential relief or reliefs as claimed and answer of last issue also goes against the plaintiff. Thus, in view of the discussions made above, it is hereby ordered that let the suit be the same is dismissed on contest but without any cost, and plaintiff is not entitled to get her 1/7 share in Schedule B property as claimed.
And the appellate court has said that possessory right remains.
Yes. Yes.
It will not be binding on the property.
Yes. Only to the extent of possessory right. And with respect to the property, the sale of the property, it has come to the finding that in the sale deed, mention of the daughters along with the plaintiff
So
is
it
not.
has not been executed.
Sale deed has been admitted by them that it was, and it has been admitted
Name
by
of
the
daughters was not.
no.
And the appellate court also does not record a finding that she received any payment.
Yes, she has received because
That finding is not there.
no. The appellate court has not recorded.
Has not recorded anything.
Only the admitted fact is 1.5 or 2 kattas of land which fell in her share that has been given to her.
The
She,
appellate court has not said that she will be entitled to retain that particular property. The appellate court has included even that property for the purposes of that. That has not been excluded.
no, that was not.
Now let us see each question one by one. First,
Yes. Whether in view of the fact that major portion of the suit property was sold far back during the period 1986-2000 and the plaintiff never objected to the said sale or handing over the possession to the purchasers, the suit is barred by principles of waiver, acquiescence and stop. So she has admitted that she had the knowledge that the land in the name of the common ancestor has already been sold out far back, and she never objected to that. Next is whether in view of the fact that all the co-sharers of the property have affirmed the previous partition amongst the co-sharers and also distribution of the share of the consideration amongst all the co-sharers including the plaintiff, the present suit for partition is maintainable.
how do you say that they have affirmed the previous partition?
In their depositions, all of them have stated that they have
The
received
trial court has recorded a finding that there was previous partition because nobody says that there was a previous partition. Because nobody says. Even the defendants never pleaded that there was a previous partition.
defendants. They have pleaded that the land which is recorded in the name of mother is her self-acquired property, cannot be divided.
Sagar,
That is his.
That is his
Ah.
property.
His property,
And so far
common
as-
ancestors' property, that has been already sold out and the share has been given. So there is no.
Therefore, in view of the fact that all other co-sharers of the have affirmed the previous partition, this is not correct. There is no affirmation of previous partition.
All the co-sharers have stated that they have received their due share and
Out of
the
the
land
sale.
out of the sale, out of the joint family property. They have sold out the property and they have received their due share. Even the land was given to the plaintiff and she never objected to the land which was being sold to Vijay Heritage and she has received the consideration.
What is the third one?
Whether in absence of any separate source of income, admission of the plaintiff of purchasing a new house and also having an old house over the part of the suit property proves previous partition amongst the co-sharers and also sharing of the consideration amount received against the sale of part of the suit property which has been specifically affirmed by all other co-sharers in their evidence. So she had no source, a separate source of income. She says that she has purchased a house. Same is applicable to the mother. She at least says that it has been purchased by the Stridhan.
She never said.
It has come, the WS which has been filed, that is a common WS by all the
She has
defendants.
not come and deposed.
She has not deposed Vijay. But as far as WS being filed by all the co-sharers of the property, all the common ancestors, defendants, it has been stated that it is the land which was purchased by Stridhan. Even the sale deed which has been the sale by which it has been procured by the plaintiff has not been exhibited that this has been procured by her. But it is an admitted fact that she has procured the land with having no other source of income, and also it is an admission that she is also having the possession and the land was given to her and she is in possession of that land.
That's all.
Lady.
Ms. Conant?
I'll directly answer the questions which have been formulated. Your Lordship, she has already read out the entire judgment, and Your Lordship would find from the Appellate Court's judgment that the entire thing has been considered by the lower first Appellate. And because the entire thing has been considered, and this was, I'll just refer to the substantial question of law. 2 and 3, Your Lordship would find, 3 in fact, is related to previous partition. So, if there was no plea with regard to the previous partition and their pleading, absolutely no plea, no date, no year whatsoever as to when this previous partition took place. They could have even vaguely said that this was the year of partition and thereafter, therefore the suit was not maintainable. And after partition, the property was sold down and the consideration amount was then distributed. All these pleadings are not there. Essential pleading that with regard to the date or year of partition is missing. Therefore, the question of law number 3 is absolutely does not call for consideration by this Honour. And what the 3
Just a
says.
moment. They made a specific statement in the plate that there was no previous partition.
We had said. I was the plaintiff.
Yes. You have
Yes.
said.
Yes.
Did they respond to that?
No. They do not. They simply, Your Lordship, I have not found anything by which they say that no, there has already been a partition. There is no such thing. I only have the judgment, Your Lordship.
I understand.
But even assuming that there was a big plan, let us assume.
Let's have a look.
Yes, yes.
There is a para 13 of the WS, it has been mentioned. That the partition of the land belonged to Hemchand Gunai has already been done and all the members have taken their respective share by land and consideration amount in the year 1986 to 2000. Page number 5, para 13.
So they have made out a specific case in their written statement that the entire property is standing in the name of Plaintiff, whatever his rights, what as that has been sold, and each one of them have taken one now. This is what they call about the
Yes, yes, yes.
Money and land both.
They could have said. Now, they do not say that there has been a previous partition. They only say that because it has been sold and the concession amount has been distributed, then therefore that amounts to partition. Now, Your Lordship, the appellate court, first appellate court comes to a very specific finding that there is absolutely nothing to show that I have received any amount whatsoever. So, if I have not received any amount, then how can my partition suit be dismissed on the ground that I have received the
In
concession?
a case, Mr. Rahul, you just tell us, in a case where the properties are sold, maybe by the co-share, that is assumed, that would at best be your case, that by the co-share, the property is. So what happens when the partitions would
I would get the share of the remaining, I'll get the entire 1/7, and our entire property has not been sold. They themselves say that major portion has been sold. So whatever is left out.
They say there are three kinds of properties. One is standing in the name of Sagar Gorai. He has not purchased it from you. It is only in the record of rights he is shown as illegal possession. Another is in illegal possession of
Mother.
money. Third is mother had also purchased some property through Jharkhand. That sale has not been produced. She has also not been closed. That the source of it. Now the properties which are sold, which are shown as in illegal possession of individual persons in a joint family, can they be subjected to partition?
Exactly, this has been dealt with by the appellate court, and then by there are other judgments also. The appellate court says, I'll get whatever right, I'll read out that portion. Para 38. Para 38, Your Lordship.
First 34.
34. Yes. Hence, from the above facts, I found that the suit property mentioned in Schedule B, except plot number 1230 and 1232 of Khata number 1217, are joint properties of both parties. Why he is coming to this finding?
Yes,
Your Lordship,
1230 is what?
yes, but why he is coming to this finding? Your Lordship would find in previous page. That means running page 21, para 27.
Yes.
Hence, the above fact and circumstances, it has come clear that the land shown in possession of Sarla Gurai, defendant number 3 and defendant number 2 have been acquired by earning of joint property. So, source of nucleus of income in of joint family. But from the perusal of Exhibit 1 by A, it has been clearly shown that the land of plot number 1230 and 1232 of Khata number 1217 is shown in possession of Tata Iron and Steel Company. So, in these two plots, neither of the parties are entitled to. Therefore, he excludes that. And we have not filed any appeal with regard to that finding. So, finding with regard to those two plots are fine.
Then where is
And
the
then-
finding that the properties which are standing in the name of Sagar or standing in the name of mother in the record of right as illegal possession will also be subject?
Yes, therefore he says in para 38 itself that except it is therefore ordered that the plaintiff 1/7 share in the suit property mentioned in Schedule B of the plaint, except plot number 1230 and 1232 of Khata number 1217, and the plaintiff is entitled to get 1/7 share only possessory right to the land which is recorded in the name of government of Bihar, now Jharkhand. It is shown in illegal possession of so and so and the defendant, but it shall not be binding on this. So he takes care of that. That whatever right the person who has been shown as illegal possession, that right I have. That
And
right.
what about the property which has already been sold in name of Vidya Homes?
What would happen? That
What is the finding?
Yes.
Vidya Home is in relation to plot number?
Khata number 1108.
110. This is the only property which has gone to Vidya Homes.
Yes.
What is the finding in connection with 110? where is the finding that she got no share in that?
Yes.
There is a discussion on 1108.
I read that where the first appellate court says that they have failed to prove this fact that the entire concession amount.
Where is-
1108 पे कोई कुछ
Where is that? They are failed to prove that.
वही
Median amount was received.
One 1108 has not been specifically mentioned in this finding portion.
From the statement of both the parties. You come to internal page, maybe 11.
From the statement of, yes,
From the statement.
statement of DW1, who is himself the defendant number 2, has not come and that on what date actual partition was taken place, and in his cross-examination he has only stated clearly that there is no name of his sister as in the sale deed, which clearly which shows clearly that plaintiff has not sold the land of Hemchand Gurai. DW1 has stated in cross-examination that he cannot say what number of land was sold by him, and he admits in cross-examination that at the time of his death of his father, there is any business of him, which shows clearly that at the time of death of his father, he had no independent source of income. From the statement of DW2 and DW3, as stated in cross-examination, it has come clearly that the suit property is joint property and it has not been partitioned, and the defendant have not filed any receipt to show that the plaintiff has received such a huge amount as alleged by the defendant, and the defendant has not filed any sale deed to corroborate that all the lands have been sold. So from these statement of the defendant witnesses, it has come clearly that the suit property has not been partitioned by meets and bounds. From these statement, both the parties, it has clearly come that the plaintiff is the daughter of the common ancestor Hemchand Gurai, and defendant number 1 is his wife, defendant number 2 and 3 his son, and other defendants are his daughters. So it is clear that the plaintiff is entitled to 1/7 share of her father Hemchand Gurai. Defendant number 1, Sarlabhala Devi, has not come to depose in the case to corroborate what she has purchased of the lands from her Sridham. So without corroboration from Sarlabhala Gurai, it has not been proved that some of the lands have been purchased by her from her own Sridham. And in the cross-examination, this is also important. And in his cross-examination of DW1, it has come that mother of the defendant has no business and she is only housewife, and it is admitted that defendant number 3 was a child. Defendant number 3 was a child at the time of his father Hemchand Gurai, so he had no income at the time of death of his father.
Even the plaintiff was a child.
Yes.
From 11 to
Yes,
20.
everyone.
They were all children.
And here, Your Lordship, whether the properties were acquired by whom, whether there was nucleus or not, this is not the substantial question.
This is not
They-
in dispute also.
not in
because
dispute
They say
also.
that
Yes.
the share was given.
Yes, only yes. Exactly.
They say that that's what I said. Once they say that the share was given, you admit that there was a nucleus.
Yes, absolutely.
Otherwise, there was no question of giving share.
Yes. And therefore, whatever was raised by them has already been answered, and they have not been able to show that as to what amount they had paid.
So whatever question of law has been framed by referring to previous partition is absolutely irrelevant.
Absolutely irrelevant, and your lordship may see.
And merely,
First
merely because some share is given, that does not amount to partition.
No, absolutely not.
The finding
This
is
has
that
not-
there has been no partition by Nixon.
Yes, and this has to be shown that by receiving that amount, I relinquished my right to seek partition. So neither there is pleading nor there is any document whatsoever to show mere inferences that I have a house nearby, thereby only to come to a conclusion that I have consented to any such dealing is absolutely erroneous. Secondly, as the learned counsel for the appellant argued, that I have a house nearby and it is, let us assume, my father's property I have been given. It is only a property that would be taken care of
That
when
would-
final allotment of
That
1/7
would
share.
also be subject to
Yes,
partition.
absolutely, absolutely.
Has she excluded that property?
No.
She has not excluded. Has she has the
It is
plaintiff
not-
excluded that property?
There is no mention as such, ladyship, that which is the khata number and the plot number, which is being possessed. She is having the possession. It has been admitted that the old house and the land of the father is in her possession, and that was given to her. But it belongs to which khata number and what is the plot number, that has not been mentioned in the entire
In the
judgment.
records also it is not.
It has
When,
not been
when
mentioned.
they came up with this plea, they were required to show that because of this reason I was not entitled to.
It is an admitted fact, ladyship. Even in the cross-examination, she has admitted.
Even if she is in possession of such property, which falls within the schedule, then under such circumstances she would be even that property will be.
She
subject
should
to
have come,
partition.
approached the court at least with the clean hands, my lord. In 1989, to
Merely
do the-
because one of the co-sharer is in possession of the property, merely because one of the co-sharer has improved the property, that will not disentitle or take it out of the purview of partition.
but she should have come with the clean hands that she is having the possession, which is the
Possession is irrelevant in partition. See, one may have lots of property in village and they are not in possession for continuous 50 years, but still it's joint possession. If it is a joint family, it's joint possession. As simple. Correct?
and the case of the defendants right from the beginning is the only property which was in the name of the common ancestor has already been sold long back.
You have not produced any sale deed.
The sale deed, that is again admitted by the plaintiff herself that yes, the land has been sold.
So whatever be the share of that, is entitled to that. And if you have taken the entire sale proceeds, then she will be entitled to that portion of the sale proceeds. This will be decided in final partition. This is only 1/7 share which has been decided. Finally, when that final partition is done by takta bandi or whatever, then under such circumstances only it can be decided. And otherwise it can be decided.
My cases.
At the stage of takta bandi, this sale deeds can be looked into.
What happens actually, that I'll be fair. The trial court, what it says, it would not unsettle the transfers which have already been made and the purchasers who have already been put in possession. And what ultimately, after the preliminary decree is passed, here the question is whether I am entitled to 1/7 share in the entire property or not. This is the only question. Now, when the final decree proceeding starts, then it would be seen as to where that 1/7 share I would have. That is, then the court says or looks into possession and transfers, it takes into account what property has already been transferred, what is the leftover, and in the leftover property,
Maybe at the time of final allocation of shares, the property which you already have
Yes.
can be earmarked and left.
absolutely, that would be taken care of, and that portion would be allotted to me as 1/7 share, and it would be deducted from my share. And if I am entitled to more than that, then obviously I'll be given. Or if I am in possession of more than 1/7, then I'll
You have to relinquish.
yes, absolutely. I cannot say that I'll have more than 1/7 because I am the one who has come forward. And
Why did the plaintiff leave out certain property from the package? Some property has been
Yes.
left
yes,
out.
that statement is there in
Yes.
Ghatshila because it was in different jurisdiction, but that was erroneous. Because your lordship, there is a provision where it says that if the suit property falls within different jurisdiction, then any of the court can have the jurisdiction to decide.
Yes, entire property
But
has to be taken.
here it was not their case that the suit was bad for partial partition. It was not their case.
It was not their case, nor any such question of law.
No.
Rather, the suit was filed only for partial partition.
Yes. Two, three blocks.
It could be made because of the reason that it could be that she is in possession of that property.
Maybe.
Maybe that she is in
But
possession, she is
no
not
such
bothered about it. Why should she
no
go?
such case has been
No
made
such
out.
case has been made out. So, especially it's a case of partial partition, not complete partition. You just have a look at it.
Yes.
She has herself left out this
Let-
property.
Therefore, this that the suit is bad for partial partition, that was required to be specifically
No, that's
pleaded
not a
by.
question of law. We will
Yes.
not enter
They
into
have
that.
neither pleaded nor any question of law has been.
And as it is, if some partition, if that property is in possession of the plaintiff, the appellants can still go for the partition of that property.
Absolutely,
There is no problem. Because
absolutely.
that portion of the property has been specifically excluded. She's a married daughter, no? She might be living there. Maybe that she has constructed a house there.
No, they themselves have said that she is living here itself.
We do not know. What
And
is the reason, or maybe wrongly
if-
advised.
If it was actually in our possession, then they would have certainly made this an issue before the court. That I have left out the property which is in my possession.
There is no such
No,
such,
absolutely.
they are not joint issues.
Absolutely. And your lordship may see the questions of law because it has been framed and your lordship, it has to be answered. First, I was reading substance. First,
One.
yes. Whether in view of the fact that major portion of the suit property was sold far back during the period of 1986 to 2000 and the plaintiffs never objected to sale or handing over possession to the purchaser, the suit is barred by principles of waiver, acquiescence and restoration. Now here the question could have come, there is absolutely no bar in transferring a portion of a property by any co-sharer. No law which bars transfer of property by a co-sharer. So that would only be binding to the extent of the right which he possesses. So if there is no bar, then whether I could have filed a suit immediately that you please declare the sale as invalid, my suit would not have been maintainable. So therefore, merely because the properties, some of the properties were transferred, that does not mean that the suit
And
was.
that judgment has been considered also. That there is no legal bar in selling property by co-share.
Yes.
That judgment, we were reading that judgment has been considered. Maybe cited. Here it is. Internal page 15 of the trial court.
Yes.
A reference was made.
Ruling referred to
referred
in handwritten to. Yes.
So, what do you say to this finding? Is there any legal bar in selling of the property of the file?
There is no legal bar, ladyship, and there is also a judgment which says that the karta of the family or the adult member of the family, here also it is evident that he is the karta of the family, he can sell off the property for maintaining the family.
No, but that is not his case.
No,
He has not made out a case of legal necessity.
No, he has deposed. That he has, because his father was suffering through,
When did his father die?
76.
76. So suffering from whatever, the cancer, and then
And all the
property sold in 86 to 2000, and then he says that the sale proceeds was distributed amongst all. So it is not a case of legal necessity.
Apart from that, whatever the property, because marriage and everything was done,
You have not made out a case of legal necessity. That is not your case. Sure, that is a case of legal necessity. He says that I have spent so much.
yes.
That is a separate thing. But he has not made out a case of legal necessity. Legal necessity, yes. If the Katta is selling off the property for legal necessity, that is binding on the entire family. But he has not made out a case. It is not your case. That is a case of legal necessity. And then this.
Then they could not have taken a contradictory plea that after selling, I have distributed the consideration amount.
After selling, he would have spent that money for the purpose it has been
Yes,
sold.
exactly.
That is not your case. Legal necessity you cannot take care.
Then second question, whether in view of the fact that all the other co-sharer, your Lordship may kindly take note, other co-sharer and also distribution of the share of the concession amount, concession amongst all the co-sharer, including the plaintiff, the present suit for partition is maintained. Here the appellate court has clearly come to a finding that the defendants have failed to establish that any concession amount was paid to me. They have neither brought any sale deed nor any receipt receiving the concession amount from me. So if that was not there, merely because the property was sold and they had taken this plea, that does not mean that this question therefore does not fall into consideration. Because the essential fact.
Neither there was any affirmation of previous partition, nor the distribution of shares of the consideration has been
Proved, yes. It was not. Now third also is again.
Just let
Yes.
let me answer. What do you say to this?
Leadership in all the co-sharers, even the married daughters and everybody, they have affirmed that the property was sold, they have got their due share, and they have also stated that the
plaintiff has stated that she got a due share.
no, plaintiff has always denied. She has
He
been
has always denied.
She
All
has
of them
denied.
are only making oral statements.
Yes, that the amount was.
No proof.
The proof is that she herself says that it is her self-acquired property, leadership. If the same is applied on the defendants, that they had no separate source of income from where they have purchased the land, the same would apply on her, ladyship, that from where she has purchased the house, new house, and she has not denied the fact that she has the land of her father. She was residing in that house, and in this.
That will also be subject matter of partition.
And what about the self-acquired property by this lady? She says that she has acquired the property and she has built a house. We say that from the consideration amount that has been given to her after selling of the property, from that amount she has purchased the house. And she has not.
You have three bifurcations. One is 2,50,000 paid in 15.
Yes.
No document,
No.
right? That goes. Then you have
18 lakhs.
no 18 lakhs is inclusive of 2 lakhs.
8 lakhs. 8 lakhs.
Yes. And then you have this. $8 lakhs for the purchase of new house. This is the amount which you say you have paid to her for the purchase of new house.
Yes.
What is the mode? You must have paid cash. You must have paid it through some process. And what was the consideration amount of the properties that you have sold? Even the total consideration amount is not there. How was it distributed? How rupees 8 lakhs was paid? There is nothing.
Total consideration has not been brought on record.
Total
Ladyship, but-
consideration is not.
Yes.
Right? How this, what is the mode and manner of payment of 8 lakhs is not there. and she is married. So she may have multiple sources of income. A lady would be entitled for a share in a parental house, and at the same time, she's also entitled to whatever is there with her husband.
No, she has stated specifically that she has no separate source of income. That has come in her deposition, that she has no separate source of income. So if that is applicable on the defendant's mother, that even if she has stated, it has come in the WS, that it was purchased through her Stridhan. Sagar Gorai, who has
This is that
maintained...
statement where it has come that she has no separate source of income. In her cross-examination, she must have said.
Yes. Page 7, leadership, para 21, 22 of her cross-examination. Some of the pages are missing with me as well, but I have some pages on which I
Of cross-examination.
Yes.
Of
Cross-exam, no, this is dependent number 2. This is not. Evidence of, yes, leadership. Evidence of Chhabi Gorai PW1 on affidavit. First page, behind that page, immediately behind that page, handwritten. मैं बंगाली हूँ तथा बंगला जानती हूँ. मेरे ससुराल बलरामपुर थाना मागमुंडी जिला पुरुलिया के बगल में है. मेरी पढ़ाई बंगला मीडियम में हुई है. मेरे बड़े भाई की शादी लखनपुर जिला पुरुलिया पश्चिम बंगाल में तथा छोटे भाई वीरेंद्र गोराई की शादी पुराने मकान में मैं अब नहीं रहती हूँ. 1 वर्ष पहले नए मकान को खरीदा एवं उसी में रह रही हूँ. पुराना मकान पिताजी की जमीन पर स्थित, जिसका खाता नंबर एवं प्लॉट नंबर नहीं मालूम. वह मकान, पुराना मकान अभी भी मेरी ही दखल में है. पुराना मकान 1.5 से 2 कट्ठा जमीन पर बना हुआ है. गीता गोराई मेरी बहन है जो सोनारी में रहती है. मेरे पुराने मकान के नज़दीक में विजय हेरिटेज नामक फ्लैट बना हुआ है. 1989 ईस्वी में लगभग विजय हेरिटेज बना है. इसमें विजय हेरिटेज बना हुआ है. वह ज़मीन मेरे पिता की थी और अन्य ज़मीन भी दूसरे लोगों से विजय हेरिटेज में शामिल है. खाता नंबर 1217 की ज़मीन मेरे पिताजी ने खरीदी हुई ज़मीन है, जिसका दलील मैंने दाखिल नहीं किया है. खाता नंबर 1217 में प्लॉट नंबर 70 एवं 72 मेरे भाई सागर चंद्र गोराई अवैध दखलकार के रूप में दर्ज है. इसकी जानकारी मुझे नहीं है. 1217 नंबर खाता बिहार सरकार के नाम में दर्ज है तथा अवैध दखलकार सागर चंद्र गोराई दर्ज है. इसकी जानकारी मुझे नहीं है. खाता नंबर 1108 में ज़मीन मेरे पिता की अभी है कि नहीं, इसकी जानकारी मुझे नहीं है. खाता नंबर 930 की ज़मीन मेरे माँ के नाम से भी वह बिक्री हुई या नहीं, इसकी जानकारी मुझे नहीं है. लगभग पूरी ज़मीन बिक्री हो गई है. मेरे पिताजी की मृत्यु 1976 में हुई. उस समय मेरा उम्र लगभग 10 से 11 वर्ष था. मेरी शादी 1986 में हुई थी. शादी में कन्यादान मेरे बड़े पापा एवं माँ ने किया था. माँ ने शादी का खर्च वहन किया था. मेरी माँ अभी भी जीवित है. 86 से ही ज़मीन बिका है. मुझे इस बात की कोई जानकारी नहीं है कि मुझे 2.5 लाख रुपया मेरे भाई ने दिया था चिटफंड में के घाटे से उबरने के लिए. मुझे इस बात की जानकारी नहीं है कि मेरे भाई ने
cross-examination that she has no source of income. Okay. There is no cross-examination on this one. ऐसी बात नहीं है कि मुझे मेरे भाई ने जमीन बेचने के बाद 18 लाख para 17 of, para 18 of the chief. Para 18.
Para 15, 16, 17, 18. Which is false to suggest that plot number 106 and rupees 2 lakh rupees in cash for construction has been given to me, and apart from that I have taken rupees 8.50 lakhs from for another house property. In total I have taken 15 lakh from the defendant number 1, 2 and 3 for my share, and apart from she has taken rupees 2,50,000 for paying check fund. It is also not correct that for the purpose for say that the purpose in suit is not the property in suit is not joint family property of the family. It is false to suggest that defendant number 1, 2 and 3 are the absolute owner of the properties.
Point number 3.
Yes. To end point number 2, Your Lordship, the first appellate court, being a final court of fact, it is within its power to come to a finding on perusal of evidence, and the finding which the appellate court has come to, that no consideration amount whatsoever was paid to her, cannot be said to be perverse.
There is no such point of law.
No, because they are this question of law which they are saying that it was distributed and I had taken the consideration amount. This the appellate court says that there is no consideration amount was paid and there is no absolutely no document to prove that. This is the finding. So then question number 3, can I? Whether in absence of any separate source of income, admission of the plaintiff of purchasing a new house and also having an old house over the part of the suit property proves previous partition. No case of previous partition, so by its own this question could not have been formulated, that this question never fell for consideration. All these facts by themselves cannot prove previous partition because there is no case of previous partition.
Then what about the first sentence, whether in absence of any separate source of income?
First, yes, whether in absence of any separate source of income, admission of the plaintiff of purchasing a new house and also having an old house over the part of the, let us assume that I do not have any source of income. Then how does it affect my right to seek a partition?
They say that you have purchased this new house from the source.
Because I have denied. So it was for them to have proved that how that amount was paid to them, paid to me. The appellate court on discussion of entire evidences, it comes to a finding that absolutely nothing to show that I have been paid that amount. And no suggestion whatsoever that this statement was false or
PWT 2 may kindly be seen, Ladyship, for a moment.
PW2 will not decide, will not depose on the source of income of PW1.
And
No,
there
no,
is
no. Chhabi Gorai has got one. This is PW's witness, Ladyship. That may kindly be seen once. Chhabi Gorai has got 1/7 share in the suit property. This has been stated by their own witness, PW2, who has come and deposed in her favor. In para 6, he has stated that 1/7 share has been given to Chhabi Gorai.
That she has already got.
And she has already got. That has come in the deposition of the PW witness number 2.
Who is PW?
PW2 is residing next to her 1.5 kilometers, and she has brought before the court below to depose in her favor.
It is not the finding of either court that she has received 1/7 share of it. Is it the finding of either of the courts?
The
We are
court,
one deposition. We are not here to reapprise evidence. Even a finding of fact in case of reversal also. The finding of fact at the appellate court is a finding of fact on basis of materials on record. There is no such question of law claim that this finding is incorrect or this finding is perverse. There is no such question of law claim. That is is why, while framing question of law, it's extremely important what kind of question of law is being framed. It's almost, while framing question of law, the hearing is half done.
At the time of admission, our whole endeavor is to somehow get
Yes.
through the first
I
gate
spent
and
a
then
lot of time in framing substantial question. And by the time I frame it, I've already decided what I have to do to this question of law. There is no such finding that this itself is perverse. The finding of fact recorded by Appellate court, even in case of reversal, is a binding finding of fact. You cannot disturb that.
and last, there was substantial difference between the two. Now here the original Sarla Bala, she did not come to depose, whereas the plaintiff, she had come to depose. She specifically came to the witness box, she asserted whatever was there in her claim. And whereas on the other hand, the defendant number one, who is the appellant number one hearing, she did not come to depose that the fact that it was purchased by her from her
Appellant number one is the mother.
mother.
Yes.
छोड़ के मत जाइएगा, सारा सबमिशन लिखा है, कोर्ट छोड़ के।
ठीक ठीक
क्योंकि एरर हो जाएगा तो
नहीं,
परमानेंट एरर होगा।
ठीक ठीक
कम से कम सबमिशंस पे कोई गलती नहीं होना चाहिए।
ठीक
और जब मैंने काफी से क्लेम बन गया और वापस this document has been filed against the judgment dated 9 October 2015, wherein that is 3 dated 24th of November 2015, and passed by the district judge on the 9th of April, entitled partition and appeal number 2 of 2010, whereby the appeal has been allowed. The trial court judgment is dated 24th of November 2009, and that is duly signed on 4/2009, passed by the late subject number 6, is similar entitled whereby the suit was dismissed. The defendants are the appellants before this court. Only 3 of them have come. Out of 6 defendants in the suit, only 3 of them have filed the resistance. Out of them, the appellant number 1 is Shrimati Sarla Bala Godain, wife of Hilton Godain, and on account of her death, her name has been deleted by the order dated 16/12/2001.
We were not aware about her death. Now, Your Lordship, there's one more question.
I'm coming
Yes,
to that.
yes.
I'm coming to that. The order dated 16/12/2021 reveals that through interstitial application being ID number 5707 of 2020, the appellant sought to delete the name of appellant number 1, Shrimati Sarla Bala Godain, by stating that she died on 22/11/2018, leaving behind her 2 sons, namely Sarkar Chandra Godain and Hiren Chandra Godain, who were the other 2 appellants. in the second appeal. However, the suit reveals that there were altogether 5 defendants. Defendant number 1 was Shrimati Sarla Bala Durai, widow of Angel Durai, and other defendants were her 2 sons, Sagar Chand Durai and Udai Chand Durai, and who were defendant number 2 and 3, and other defendants were the daughters of Sarla Bala Durai and Angel Durai. क्या बोले थे?
नहीं वही that because now because of the death of Sarla Bala, her interest even otherwise devolves on all.
अभी तो ये भी decide होना चाहिए.
Yeah, because now she has died, तो उसका तो automatic हो जाएगा. Now this question whether it was her self-acquired or not, this is not required to be. Even otherwise, it is not a substantial question. But this subsequent event has occurred during the pendency of the appeal. Therefore, even otherwise, it devolves on all the 7.
That we record by recording your subjects.
Yes.
This appeal has been admitted for final hearing by the Honorable Judge 31/7/2018, wherein following substantial questions of law were raised. The counsel for the appellant has submitted that it is not in dispute that Plaintiff Chand Durai was a common ancestor who died sometimes in the 1976. It is further not in dispute that he left behind his widow, namely Sarla Bala Durai, who was defendant number 1, 2 sons, who were defendant number 2 and 3, and Plaintiff was one of the daughters, and other 3 daughters were defendant number 4, 5 and 6. The plaintiff as well as defendant number 4, 5 and 6 are all married daughters of Plaintiff Durai and defendant number 1. The learned counsel has submitted that suit for partition was filed in connection with properties of 4 Khatiyam, whose certified copy was filed before the court and were exhibited as Exhibit 1 in 1/C. The exhibits were relating to Khata number 1217, 929, 930 and 1108 listed. He submits that so far as property involved in Khata number 1217 is concerned, it was recorded in the name of Allahabad Bihar Sarkar, and certain plots, particularly plot number 2343, 2343, 2337, 2338, 31 and 2191 in the Khata number 1217 was shown in the illegal possession of common ancestor, namely Plaintiff Durai. So far as plot number 1230 and 1232 of Khata number 1217 is concerned, the same was shown in illegal possession of this. She has further submitted that so far as plot number, so far as Khata number 929 and 930 are concerned, the same were shown to be in exclusive possession of defendant number 1, wife of the common ancestor, namely Newton Gorai and mother of the plaintiff. She has further submitted that Khata number 1108 stood in the name of the common ancestor, namely Newton Gorai, and all the plots and the entire Khata number 1108 was sold out to third party and formed a part of Vijay Heritage and was in possession of the purchasers. She has further stated that the property in Khata number 1108 were sold out by the two brothers and mother of the plaintiff by virtue of registered savings executed during the period from 1986.
Ship 1 was left, that is Khata number 1217, plot number 70, 72, I left at that point of time also, 70, 72, 109, 110, 2043 and 2044 belongs to Sagar Gorai, that is defendant number 2 as self-acquired.
Just a minute. Khata number
1217.
1217 stood in the name of
Sagar Gorai, उसका कुछ plots because 1217
उसका कौन सा plot?
plot number 70,
70,
72,
72,
109,
109,
110,
110,
2043
204,
and 2044
204.
belongs to Sagar Gorai
As
that
in his
self-acquired
possession.
as self-acquired property.
1217 is Annabad Bihar.
अनाबाद बिहार सरकार का ये जो प्लॉट्स है as self-acquired property of Sagar Gorai.
The learned counsel has further submitted that a portion of Khata number 1217 was recorded in the name of the eldest son of the family, namely Sagar Gorai, and those properties were relating to plot number 70, 72, 109, 110, 2043 and 2044, all in Khata number 1217. Correct?
Yes.
This is relating to which exhibit?
1217 is exhibit number 1.
Which was in relation to exhibit number 1. Exhibit number 1 entirely is Annabad Bihar.
1217
It is entirely Annabad Bihar. This is 1217. अवैध दखल सागर चंद गोराई
अवैध दखल.
so it was entirely in the name of Annabad.
Annabad Bihar's an illegal possession of Hemchand Gorai 2343, 2345, 2337, 2338, 31 and 2191. These were of the illegal possession of Hemchand Gorai in the remark column. And
जजमेंट में नहीं होगा उसको हम लोग दिखाइए कहाँ पे which property was recorded in the name of this person.
Para 3 relation. Last but third line from where it starts.
That's your time object.
Yes, yes. Running page number 29. Internal page number 3. From my WS, it has further been stated that land of Khata number 1217, plot number 70, 72, 109, 110, 2043 and 2044 belongs to Sagar Gorai, who is defendant number 2, and it is the self-acquired property of Sagar Gorai. So there is no question of jointness of title and possession in respect of the aforementioned properties. And thereafter self-acquired property of the mother.
The finding that it is in Anapad, not self-acquired. Illegal possession. There is a finding by the tribunal. Shown with respect to some clause of Khata number 1217.
Suggested.
In internal page 19 also. The legal counsel for the appellant has submitted that it was the specific case of the defendants that the legal counsel for the has submitted that it was a specific case of the defendants who filed two set of written statements wherein a specific stand was taken that the properties involved in the case do not be subject matter of partition, and the entire property belonging to Clinton Gorain was already sold out, and the plaintiff had got an amount of rupees 18 lakhs from the defendants, which was proceeds of the savings executed by the mother and two brothers of the plaintiff. It was further case of the plaintiff had also received land and house and was in possession of the same, and she also acquired a new house. It was for the case of the defendant number 1 that defendant number 2 that he was the eldest son of the family, and Himchen Gulain died due to blood cancer, and and defendant number 2 maintained all the family members, and he got his brother and sisters married beyond his capacity and had spent huge amount. It was also the case that an amount of rupees 8,50,000 was given to the plaintiff for purchasing another house property, which was included in the aforesaid amount of rupees 18 lakhs, and an amount of rupees 2,50,000 was given for paying the refund dues. The learned counsel has referred to the issues framed by the learned tribunal and has submitted that issue number 2, 3, and 4, which were taken up and decided together by the learned tribunal, were the main issues. She has submitted that by a detailed judgment, the learned tribunal had dismissed the partition suit by observing that there was a previous partition, by observing that partition had already taken place and the plaintiff had received her due share in the sale proceeds of the suit property, which stood recorded in the name of the learned counsel has submitted that the trial court had further recorded that so far as illegal possession of defendant number 1 and 2 is concerned, the ownership was of that of Anabad Bihar Sarkar, and it cannot be treated to be a joint family property, and the plaintiff was not entitled to get a share with respect to the self-acquired property of the mother, which she had purchased from her husband. The learned counsel has further submitted that the point of determination was framed by the learned appellate court in paragraph number 17. The appeal was filed only by the appeal was filed by the plaintiff, and the point of determination was framed in para number 17. The learned counsel has submitted that the learned appellate court has wrongly reversed the decree passed by the learned trial court, and upon consideration of the substantial questions of law framed by this court, the appellate court, all the substantial questions of law are to be answered in favor of the applicant, and the judgment and decree passed by the learned appellate court is fit to be set aside. With respect to the first substantial question of law, the learned counsel for the applicant has submitted that the major portion of the suit property which was sold during the period from 1986 to 2000. The plaintiff had never objected to the sale or handing over the possession to the purchasers, and the plaintiff had taken money out of the sale proceeds, and therefore the suit was barred by principle of waiver, proceeds and destruction. She has submitted that the sale of the properties has already attained finality, and there was no scope for the appellate court to put the entire suit property subject to partition. With respect to, she has relied upon a judgment passed by Honorable Supreme Court ruling that in 2020, that it was 6 387, para 10, 12 and 21, to submit that the law is very simple that burden is on the person who alleges that the property is a joint property or an HUF to prove the same. She has submitted that since the amount was, since the sale proceeds, portion of sale proceeds was already received by the plaintiff, therefore, with respect to substantial question number 2, the counsel for the appellant has submitted that all of the foreshadows that the very fact that the sale proceeds of the savings were distributed amongst the foresharer itself indicated that there was previous partition, and therefore the suit seeking partition was itself not maintainable, but this aspect of the act has not been properly considered by the
Leadership in in my WS also, it has been stated that the partition took place between 86 to 2000, when the property was sold and their share was distributed, not the previous
The
partition.
learned counsel has referred to the written statement and has submitted that a specific plea was taken by the defendants that partition had taken place during the period from 1986 to 2000, during which the property was sold to third party and the sale proceeds was distributed amongst all the shareholders.
Sale proceeds as well as land, that has also been mentioned, that the share of land and the consideration was given to each of the.
And the share of land was also given to each of the four shareholders. With respect to substantial question number 3, the learned counsel has submitted that there is no evidence that the plaintiff had any separate source of income to purchase a new house, and the plaintiff was already having a old house over part of the suit property, and therefore such conduct of the plaintiff and the specific read with the specific case of the defendants that an amount of ₹8,50,000 was given to the plaintiff for the purpose of purchase of new house itself indicates that there was previous partition amongst the co-sharers, and therefore the suit seeking partition itself was not. During the course of arguments, it also transpired that the plaintiff was essentially seeking partial partition as she had excluded certain property which was situated outside the jurisdiction of the concerned government. The learned counsel, that's all. It is all. The learned counsel has relied upon the judgment passed by the Supreme Court ruling that in 2020, Appellate 387, paragraphs 10, 12, and 21, to submit that the law is very simple, that the burden is on the person who alleges that the property is joint property the facts and circumstances of this case, the plaintiff has failed to prove that the properties which were subject matter of partition were belonging to joint family. The legal counsel appealing on behalf of the respondents has submitted that the appellate court has reversed the judgment and decree by a detailed discussion of the materials on record and the finding of facts which has been arrived at by the learned appellate court is final and no substantial question of law as such has been framed in order to disturb the findings arrived at by the learned court. With respect to the substantial question of law number 1, the learned counsel has submitted that there is no bar in transferring portion of joint family property by co-sharer. He has submitted that that a judgment of this court reported in 2004 within bracket 3 bracket 2 JLBR 205 was relied upon by the plaintiff before the learned trial court, but the state judgment has not been considered. He submits that even if some portion of the joint family property is transferred, there is no legal bar and mere transfer of portion of joint family property cannot be challenged by another co-sharer. He submits that at the time of partition, the property sold by one of the or the other co-sharer has to be taken into consideration by allocation of share. He has submitted that by the improved judgment filed by the learned appellate court, only 1/7 share in the property has been earmarked for the plaintiff and the sale of portion of the property will be taken care of once there is final partition. He has submitted that if the property is sold by co-sharer, there is no question of any waiver, acquiescence, or exclusion. With respect to substantial question number 2, the learned counsel has submitted that it was never the case of the defendants that there was any previous partition, much less previous partition by its accounts. He has also submitted that no specific date of previous partition has been mentioned in the written statement. Rather, the argument of the appellant that the partition took place during the period from 1986 to 2000 is itself cannot be said to be an element to contain an element of previous partition. For the purposes of previous partition, there has to be a particular date, and the share is required to be earned. The counsel has submitted that merely because the defendants had taken a stand that there was distribution of share of consideration amongst all the co-sharers of the property, the same cannot amount to previous partition. He has also submitted that the appellate court has recorded a clear finding that there was no evidence on record to show that the consideration amount of the sale proceeds was distributed amongst the co-sharers of the property.
And the plaintiff had received any such.
And the plaintiff had received any such amount. The learned counsel has also submitted that the property was sold jointly by the mother and 2 brothers of the plaintiff, as stated by the defendants themselves, although the same deeds are not brought on record and executed. And admittedly, the plaintiff was not a party to the suit. The learned counsel has submitted that the aforesaid findings of facts which have been recorded by the learned appellate court though by reversing the judgment of the learned high court is final and cannot be interfered with in this.
And no perversity has been.
While answering the substantial question of law, as no substantial question of law with regard to any perversity in the finding has been. While answering the substantial question number 3, the learned counsel for the respondents has submitted that the plaintiff had appeared before the court and there has been no cross-examination of the plaintiff with regard to her source of income to buy the new house. No suggestion was given to her that she had no independent source of income. He has also submitted that merely because she was possessing the old house, the same by itself does not lead to any conclusion that there was previous. He has submitted that if an old house is situated in the scheduled property for partition, the same would also be subject matter of partition. He has submitted that since there is no evidence that the consideration amount was shared amongst all the co-sharers, therefore the same by itself cannot be an evidence of partition.
Only one thing. The portion of consideration amount was paid to me. There's no absolutely no.
The learned counsel has submitted that there is no evidence on record that any portion of the consideration amount of the sale of the sale proceeds was ever received or ever paid or received by the plaintiff.
And there is a finding to that effect by the first appellate.
And there is
Very
a finding
clear.
to that effect by the learned first appellate.
Which cannot be said to be perverse.
Which cannot be said to be perverse. The learned counsel has further submitted that the records of this case reveal that the mother has already expired and this aspect of the matter cannot be overlooked as now the property which stood in the name of the mother, now there can be no impediment with respect to the division of property which stood in the name of the mother, originally.
Although there is a clear finding that it has not been proved that it was her
Although there is
property.
a clear finding that there was no proof that she had purchased the property from her stepson, rather she being alive at the relevant point of time did not even depose before the court, and adverse inference has been drawn by the learned appellate court on account of non-appearance of the defendant number 1 to testify that she had purchased the property from her own source of income.
Last, Your Lordship, again Vinita Sharma. In Vinita Sharma, thereafter another judgment, Supreme Court has taken note of the subsequent event. One is change in law and other is para 107 of Vinita Sharma, the Honorable Court has quoted. I'll just read out 2-3 lines. In para 107 of Vinita Sharma, the Honorable Court says once the constitution, and this was related to co-parcenary property, but the ultimate finding, it affects this property also, although it was the property of the other Hemchandra Borai then also. I'll only read last line. For the reasons mentioned above, we are also of the opinion that mere severance of the status by filing a suit does not bring about partition until the date of final decree. Change in law and changes due to subsequent event can be taken into consideration.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court in the case of Vinita Sharma
Rakesh Sharma
versus Rakesh Sharma reported
reported in 2020, volume 9, SCC, page 1.
Properly, 2020, volume 9, SCC, page 1, and as referred to paragraph 107 of the same judgment to submit that if any subsequent event takes place during the pendency of the suit, the same can be taken care of, and in the instant case, the mother has expired during the pendency of the second appeal. He has also submitted that once the second appeal has been admitted for final hearing, it is taken as a continuation of the suit as I had mentioned. It has to be
Continuation
taken as
of the original proceeding.
continuation of the original proceedings. That's all.
And even otherwise, Your Lordship, let us assume that second appeal was over. Then also the Honorable Court says till the final decree is actually drawn. Even
He has submitted that this continues between the parties till the final decree is ultimately drawn. He has
Yes.
submitted that in the present case it is only a preliminary decree of 1/7 share and final decree has not. Okay?
yes, have not been concluded.
Fine, the proceedings have not been concluded.
Yes.
That's all. I'll give a date for that.